At the council's last work session, there was discussion regarding a council-initiated ordinance amending the annual appropriation ordinance that would reduce the annual appropriation by an amount as a result of the city not participating in the coordinated election this November. There were some other reasons given in the discussion as to why that was appropriate, because there was an anticipated decrease in revenue as a result of council's action regarding license fees. The question came to the attorney's office: does council have the authority to initiate sua sponte on its own an amendment to the annual appropriation ordinance? The office looked at the charter and the code, and we determined that the answer to that question was no. The memo, the opinion that was distributed, issued to the mayor and then shared with council because they had a need to know, gave background, and the discussion portion of the opinion picks up where an opinion issued in 2013 prior to the passage of the 2014 annual appropriation budget was issued. Late that year, we issued two opinions that dealt with the three stages of budgets and appropriation: the preparation process, the presentation and consideration stage, second stage, and then the third stage was administration during the fiscal year. This question kind of picked up where that third stage opinion from 2013 left off. Just in summary, the 2013 opinion basically outlined that charter authorizes mayor, or the 2013 opinions in toto, the city charter authorizes the mayor to prepare and present a budget with certain charter required elements contained within it. Upon receipt of the budget, the council has the authority to review, to amend or modify the budget by increasing, decreasing programs or amounts, so long as you can amend the budget, so long as the appropriations do not exceed the revenue, or the expenditures don't exceed the anticipated revenue. Once the budget is approved, with or without amendment, the council is then shall pass an annual appropriation ordinance entitled the Annual Appropriation Ordinance no later than December 31st of that year. Then upon after the budget and the appropriations as of January 1 of the next fiscal year, the appropriations ordinance has authorized the mayor to expend funds for the programs and the purposes outlined in the budget. The appropriation ordinance is the spending authorization for the next fiscal year. Under our code, there are several points during the year when the mayor may present to council amendments to the appropriation ordinance for unanticipated revenue, a grant that we didn't anticipate and we had not budgeted for, any need to move funds from one department to another, to reduce or change the scope of a project and move funds from that project to some other purpose. And the code kind of outlines during that administration phase, stage 3, how the mayor's administrative role interacts with the council's authority to deal with the appropriations. The mayor does have some authority to move within departments under the code without seeking council authorization, but if it moves between funds or between departments, the mayor is required to come to city council for a resolution authorizing that. So the question then, whether or not the city council can initiate on their own an appropriation ordinance, really does kind of cause one to think carefully about what is the division of legislative and administrative powers in this question, and how are those powers balanced, and how are those powers checked. The opinion kind of outlines some additional provisions in the charter that indicate, in like 2 or 3 sections, that the mayor has sole executive and administrative authority with regard to the operation of the city, and the council retains all the legislative authority. This division of powers is clearly present in mayor prepares budget, council approves budget with or without amendment. Council then appropriates to provide the mayor the authorization to spend in accord with the budget. The powers are divided, but they're also balanced because each one is kind of dependent on the other, and together they work toward the good of the city. Here the question was council interfering and taking on an administrative or an executive role in initiating its own appropriation ordinance that interfered with the mayor's power? Was this a confusion of the division of powers? And to answer that question, what we needed to do was to go back into the charter, and I'm talking specifically about section 4-10, where it specifically says there shall be and hereby is created the office of mayor. Mayor shall be chief executive, shall enforce all laws and ordinances, possess, have, and exercise all the executive and administrative powers granted to the city by the Constitution, and all executive and administrative powers contained in the charter, and as otherwise existing by operational law, except as hereinafter delegated to the departments hereinafter created, and except the powers granted to other elective officers by this charter. This provision of the charter, which again is consistent with the council mayor form of government we've adopted, has basically said the mayor does all the administrative stuff, the other elective officers do all the legislative stuff, unless the charter specifically gives the council an administrative function. And in this particular instance, the charter did not give the council the administrative authority to propose appropriation amendments during the fiscal year. The material that I presented or put on your desks today and that we were going to be talking about in closed session is a copy of the Colorado Local Government Budget Law. It's found in Title 29, Article 1, Part 1 of the Colorado Revised Statutes. By definition, this act does not apply to the city of Colorado Springs, okay? But I'm using it as an example for how local government in Colorado is supposed to behave with regard to their budgets, their administration of those budgets and appropriations during the year. In section 29-1-102 definitions, subsection 13 defines local government. I've highlighted on your copy the relevant provisions. It says local government does not include any home rule city or town, home rule city and county, cities and towns operating under a territorial charter, and the other enumerated provisions. So I want to make it perfectly clear that this act does not apply to the city of Colorado Springs. However, I have also highlighted, and we're going to discuss, how our charter adopts 90% of this act. And so if we were to take this question, who's has authority to initiate appropriation ordinance amendments, to a court, they're going to say, well, if it's not explained in your charter, find me something similar. This is what they would go to. When you look at section 29-1-103, budgets required, I've highlighted for you on the left the provisions of the charter that match up with the different requirements that the act has for budgets in local governments. We are required under our charter to complete a financial plan by fund and by spending agency. We do that by department, and we do that by special funds, enterprise funds, general costs, those types of things. We have to include in the budget all proposed expenditures for administration operations, all of that. Anticipated revenues for the budget year. A written budget message describing the important features of the budget, describing the budgetary basis of accounting, which Cara assures me is the encumbrance basis, which is defined back on the page 1 in the definitions. We have to have explanatory schedules or statements classifying the expenditures by objects and by revenues of source. And, also similar with our charter, no budget adopted pursuant to this section of the Act shall provide for expenditures in excess of available revenues and beginning fund balances. So the city does exactly what the state would require with regard to preparing the budget. By whom is the budget prepared? We look at section 104. Governing body of each local government shall designate or appoint a person to prepare the budget and submit the same to the governing body. This was taken out of council's hands when the charter specifically said that the mayor shall prepare and present the budget. And that's in charter section 4-40I. Budget estimates in section 105 talk about what are the estimates of expenditures. We have to talk about how we're going to be anticipating revenues. Section 108 is adoption of budget, appropriations, and failure to adopt. The statute requires a hearing. We don't. However, when we notice our agendas and we put the ordinance on, the public is always, pursuant to our rules, authorized to stand up here and support, object, comment upon. So we do hold a public hearing with regard to our budget and the appropriations. It talks about setting of the mill levy, which are, again, all consistent with the charter. The interesting thing about Section 108 is the very last section, Section 6. And it says, all unexpended appropriations or unencumbered appropriations, if the encumbrance basis of budgetary accounting is adopted, expire at the end of the budget year. This is an important section because it is the only part in the Act that talks about any overage, any savings as a result of your budgeted activities at the end of the year. And only then do any excess savings or anything that you didn't spend get swept back into the general fund, the undesignated reserve. It's the only part of the Act that doesn't talk about appropriating at the very beginning of the budget year. Section 109 does talk about changes to the budget, transfer, supplemental appropriations. After adopting the budget, the governing body deems it necessary, it may transfer appropriated monies between funds or between spending agencies. It's in our code. If after adoption of the budget, the local government receives unanticipated revenues or revenues not assured at the time of the budget, the unforeseen grant, governing body may authorize expenditure by enacting a supplemental budget and appropriation. Again, covered in the code. In the event revenues are lower than anticipated in the adopted budget, governing body may adopt a revised appropriation ordinance. May adopt, all legislative functions. The Act does not speak one word about the legislative body proposing the adoption of these things.
Wait.
Again, Section 110 talks about expenditures not to exceed appropriations. Section 111, contingencies. In cases of emergency, which could not have been reasonably foreseen at the time of the adoption, governing body may authorize expenditure by ordinance or resolution duly adopted. Again, it's talking about the legislative act. But interestingly, this also talks about the 3 charter provisions where the council may kind of act on its own. And I'm going to refer you to section, lost it, 7-60. No liability about appropriation. We usually think about this section of the charter meaning if we do not have funds appropriated to cover a contract within a year, we can't enter into that contract. Okay, you got to have budgeted monies or appropriated monies that you can spend on that contract, or we have no authority to enter into the contract. But the second part of this sentence, or this provision, is very important. It says, nothing herein contained shall prevent the council from providing for payment of any expense, the necessity of which is caused by any casualty, accident, or unforeseen contingency arising after the passage of the annual appropriation ordinance. It's referenced in the statute, it's in the charter, and it's also stated again in the city code. If there is a huge emergency and there is a huge problem, council can reduce the appropriation, council can appropriate more out of the reserve, but it's got to meet one of these criteria. It's got to be a casualty, accident, or an unforeseen contingency.
What charter section is that again?
Oh, it's 7-60.
7, okay.
Yeah.
Okay, just a second. We'll let you finish and then we'll have questions.
Okay. So, while this was not discussed in the opinion that we issued, I think it's really important to note that, I mean, if something happens and a court were asked to kind of resolve this issue for the city of Colorado Springs, they're going to look at the charter and the code just like we have. And then they're going to say, is there anything else out there that would guide us in helping us decide this question? And the most reasonable thing would be the other budget laws that every other municipality who is not a home rule city, and the special districts and the school districts, that they have to comply with as well. And so the point of this discussion was to illustrate for the council that this is how budgeting and appropriations are done in Colorado. During the fiscal year, it is the executive's, the administrator's responsibility to administer that budget in accord with the approval that council has given and in accord with the appropriations that council has made. Council doesn't have authority to administratively initiate the type of amendment to the appropriation ordinance that was proposed at the last work session.
Okay, we'll start with questions. Councilmember Miller.